Hi, folks. Denise Howell here. And next up on This Week in Law, we've got Kevin Thompson, Ron Rychlak, and Michael Nelson. We're going to talk about cyber gambling, parents' liability for their children's social media misdeeds, archiving the web, a Silk Road catch-22, and lots more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell, episode 279, recorded October 17th, 2014. Blame Kevin. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. We're so glad you could this week because we've got a really wonderful panel of folks to talk about the most critical issues at the intersection of technology and law. Returning to the show, joining us once again is Kevin Thompson. Hello, Kevin.
Hello, Denise. Thanks for having me.
Great to have you. Kevin is, I can't remember, Kevin, if this is the first time you've joined us since you've switched firms, but he's now with the firm of Lottis and Perry in Chicago in their digital brands practice.
Yes, thank you. It's been quite an interesting few months.
Good. We're glad you could make time to join us. And I understand you just had lunch with our good friend and my former co-host, Evan, and that you reported he's doing well.
Yes, he is. He's looking forward to getting back on the show once his new job settles down a little bit. And he is missing the show already, I'm sure.
All right. Well, we miss him bunches. But we are soldiering on, and we're going to do so today with the help of two great professors, in addition to Kevin and myself, from the Ole Miss University, is Ron Rychlak. Hello, Ron.
Hey, Denise. How are you?
I'm great. It's great to have you on the show.
I really appreciate the opportunity. I'm looking forward to this.
All right. And joining us from Old Dominion University is Michael Nelson. Hello, Michael.
Hello, Denise. Thank you for having me.
Great to have you. Now, Michael, unlike a lot of the professors that we have on the show, and unlike Ron, is not a law professor, but a computer science professor, which I think is just great because we have a lot of sort of more technically oriented stories in the rundown today. And Michael is in charge of a project. Why don't you tell us about it right now, Michael, called Memento, that is working to archive the web?
So the Memento project, it's joint work with Los Alamos National Laboratory, and it was originally funded by the Library of Congress, and it continues. And basically what we're trying to do is make it so that it is easy to access the various web archives that exist. So a lot of people know about the Internet Archive, and it was the first, it's the biggest, most popular. What people don't realize is there's a dozen or more public web archives in addition to the Internet Archive. Now, they're not as big, but if you could access them, their holdings actually add up to the size of the Internet Archive, or roughly equivalent. So basically the idea is Memento is a way to simultaneously access 12, 15 public web archives all at the same time, and you don't have to be aware of their location or how they're indexed or a variety of other aspects about Memento.
Very cool. Well, we will get more into Memento a bit later in the show. I think we will start off the show with some stories that relate to sort of criminal justice and how folks can make sure that they're staying on the right side of criminal law. And one of the areas that has been ripe for discussion that we certainly haven't paid enough attention to relating to law and the use of the online world is cyber gambling. We sometimes touch on that topic. It's a very large and complicated topic, but we're fortunate to have Ron with us today because he's spent a lot of time thinking and writing about the subject, and I think we're pretty topical getting into it right now because there's legislation pending in Congress in the United States that seeks to make all online gambling illegal under the Wire Act, that seeks to say that the Wire Act makes it illegal for any sort of wagering to happen using anything like a phone line. And I guess the internet would fall in under that rubric. Also, there at the same time, the tension in the United States is that 3 states have legalized online gambling and others are set or perhaps desirous of following suit. So we've got a little conflict there and lots of money to be made. So why don't you bring us up to speed, Ron, on where things stand legally as far as online gambling in the U.S. goes?
Well, that was a great setup you gave. There have been places for people to gamble online going back at least a decade. So online gambling has existed. The thing is, it's largely been illegal, certainly for the operators. There have been very few prosecutions of people who gamble themselves, but in terms of operating one, the feds have taken the position that the old Wire Act, the old Wire Act, in fact, prohibited this at a federal level. We go to court say, this isn't really phone lines. It's not what the law was written to cover, and so it doesn't really apply. Now there is legislation that you mentioned going through Congress trying to extend the Wire Act to explicitly cover internet gambling. So you've got that issue. You've got states that are designing gambling within the state and keeping it entirely within the state. If you can control the net that way, if you can handle the logistics to do that, gambling is a matter of state law. And so if a state wanted to have legalized online gambling and could contain it within its boundaries, a state theoretically at least can do that. Now you've got land-based casinos who both sort of are fearful of what's going to happen if we go all online. Will people stay home and gamble instead of coming out to the casinos? And so in some ways they're applying pressure to tamper this down. On the other hand, they're also thinking, if this is going to happen, we want to be in it. And so they're lining up, they're getting their pieces in order so that they can go fully into online gambling. What the issues are manifold. There's the issue of number one, do we trust the operators? If you're at a casino, we can have regulators there on site, checking the dice and making sure the machines are legitimate. Online, that's much harder to do. The gamblers trust that. We've found in some states that we tried to go to a computerized form of lottery instead of the ping pong balls, the more traditional ping pong balls. Gamblers didn't like it. And actually, we've had some glitches that have come up when we've gone to those kind of things. So there's a whole lot of issues here.
So in the U.S., we have Nevada, New Jersey, and Delaware where it's all legal. Am I understanding correctly that in order for them to have legalized online gambling, they have to have measures in place that ensures that someone like me in California can't go to a Nevada online gambling site and wager?
Exactly. And that's why while the legislation is in place to do these kind of things, they're not really up and running for traditional casino-style gambling. Now, there are near gambling sort of venues where you can play poker with one another, where you may play, you pay $20 a month, let's say, and then you play poker for fun and you can maybe win some money, but it's they take it one step away from traditional gambling if there's any risk of anything going across state lines, which means we really don't have regular online gambling legalized anywhere in the U.S. right now. I think it's part technology needs to catch up before we have really the kind of online gambling that we envision when we talk about this.
But that doesn't mean it doesn't happen, right?
Oh, of course not. It happens, and it's been happening for a long time.
So how does that shake out from a policy standpoint? It's one of those things, it's I guess we could analogize it to illegal substances, right? There is a lot of passion around legalization of marijuana. Some states have done so. There's federal tension around whether that's okay or not. But the ones that have done so have now something to tax and revenues for people within the state to be able to legally earn. Is there a similar kind of course of policy thinking that goes on concerning gambling?
The push for gambling is tax revenue. And the states that have lotteries, that have casinos, have made a lot of money off those, and they see the possibility of extending to online gambling the same way. Of course, I think realistically, if you want the real push, I think that the feds have their chance to get their nose in the tent with online gambling. So far, gambling has been a state matter. If we're really going to go to online gambling, it's almost going to necessitate federal intervention. If the feds get involved, there will be federal taxation, and that can change the balance significantly. That's why even those states that are lining up for some kind of online gambling are really kind of concerned about where it's going to go if it gets fully implemented.
Michael, as you're listening to all this as a computer scientist, I'm curious what's going through your head, the whole notion of being able to lock down a state's gambling operations to keep out others from outside the state, outside the country, whether that seems practical or not. And also, whether all of these legal niceties really make any sense at all when people are just going, people are already flaunting the law and probably will likely continue to do so, don't you think?
Yeah, I don't see how you could enforce the borders on something like that. I can understand the state's interest in doing that, but if people purchase goods and services without regard to physical location all the time, and often without jurisdiction, and then once you add Bitcoin or something else in and make it hard to track the exchange of currency, I'm not sure how it would be done.
Right. Our previous week's show was all about Bitcoin and putting things on the blockchain specifically, and how that could have other applications aside from just enabling a currency. But adding Bitcoin into online gambling does seem to be taking, I don't know, maybe it's taking two headline grabbing things and putting them together. But it seems like a very logical thing to have happen. Don't you think, Ron?
Well, if we're talking about an operation that's perhaps offshore or in a different country where the United States does not have jurisdiction, then yeah, you're right. That is a possibility. The thing is, right now, if you open up in Nevada an online casino, and I'm sitting here in Mississippi, and I can get to it, federal authorities can go there and shut it down. And that it's not that the state wants to keep things within its boundary. It's that the federal government doesn't allow gambling across state lines.
Right. So they have to be careful.
Exactly.
Yeah. What if you're an online casino based in Nevada and you're doing your best to make sure that only Nevada people are your customers, and you have decided to accept Bitcoin? Is there any problem with that you know of?
I'm not aware of any problem that would exist for accepting Bitcoin. Doing your best to limit it to Nevada is not good enough, and there's clear case precedent that you have to make sure you do not take bets from a different jurisdiction.
So do you have a good feel for what people are doing to make sure they have that degree of certainty?
Yeah, well, they're avoiding that. There really are not casino-style online gambling operations run from the United States right now. There are from other nations, from other jurisdictions. But if those folks come into the United States, they're subject to arrest. There have been a couple of arrests like that.
So where do you see this going? If we have 3 states where it's legal, but it's still too risky to operate because the federal government will shut you down, do you see any kind of movement there?
Well, the only way it's going to happen is if the federal government ultimately amends its laws and authorizes federal law to come into play. If federal law would authorize cross-jurisdictional gambling, We then would have simply the practicality of how do we enforce the regulations we put in place. And I've written a couple articles where I proposed a gateway where, for instance, a gambler who wants to gamble can go through the authorized federal gateway, get an authorized casino, which would presumably, the games would be fair and you get paid and they wouldn't abscond with your money. Or you'd have the option of going to the illegal places, the unauthorized places, maybe I should say, but you wouldn't have any guarantee that the games are fair or that they might not close down and keep your money, which has happened a couple times.
Kevin, you do a lot of stuff in the domain name area. I know that .vegas has launched and is for sale now. Do you see any overlap of gambling-oriented domains and our discussion here?
Well, I think there's going to be certain websites that come up that are certainly going to be wanting to be snatched up and used by these casinos as they branch into what hopefully for them becomes a legalized trade. I certainly can recall certain instances we've had in the past trying to enforce against other things that are happening currently. In the major problem you're running into there is the fact that it's a foreign jurisdiction, as Ron was mentioning. It's rather difficult to do anything about that. So, but I think some of these new domain names are certainly going to be used in that context. The other thing I was going to mention is I couldn't help but think of some discussions I remember hearing Professor Lessig having about code as law, talking about this is one of those ideal situations that he'd be talking about in his book, where here we have a purely digital enterprise, this online gambling, and we're trying to impose a brick and mortar approach to regulating it, when in reality, we have computer systems, as Michael would say, and point out to us, that certainly aren't designed in a brick and mortar fashion. And here we are trying to impose this regime on the top, and coming up with things like Ron's mentioned gateway and so forth as ways to try to regulate that. It's certainly a different approach if we were to come at this from a different angle. I'm not really sure what it would look like, but I think it's certainly if this comes around, where online gambling becomes more legal, we or less legal, depending on which way these laws go, what sort of forms these regulations are going to take.
Yeah, what's your take on that, Ron? The restoring or restoration of the Wire Act that is pending now. Do you have a good feel for what sort of support or lack of support it has?
I think it's unclear, and we will have a better view probably after the elections in November. The ironic thing, or the unusual thing about gambling anyway, is it's not clearly a Democrat or a Republican issue. There are folks on both sides for various reasons that support or oppose gambling. If I had to make my guess, I would say that that legislation is more likely than not to go through. That's more likely than for us to have fully legal online gambling within the United States in the next decade.
Wow, that'll be interesting to see, because that legislation would make it illegal across the board, right? So there would, Nevada, New Jersey, and Delaware would be out of luck, as would everywhere else.
Yeah, I mean, that's right. That's really how they are right now. I mean, they can't functionally operate. That's what Michael explained. Logistically, even though they have the state law, they can't make it work anyhow right now.
Let's see. Morgan Stanley released a report last month that gives some of the numbers. Morgan Stanley forecasts, and this is all just sort of saying if various planets align and things become legal, they forecast that the online gambling industry in the United States might hit $5.2 billion by the year 2020. But there are some numbers there about what's going on in the states where it's legal. New Jersey, it says, collects about $120 million in online gaming revenue each year. Nevada has about 1/10 of that, roughly $12 million. And Delaware's top month, poor Delaware, only $240,000 in online gambling revenues. So I guess New Jersey is somehow forging ahead. $120 million is not nothing, right, Ron?
Well, no, it's not. And I think what they probably include a lot of that is revenue collected at racetracks from bets. You can do bet at distant racetracks when you go to a racetrack. That's one type of online gambling that the federal government has approved. So I think that's what you probably see the majority of that money relates to.
Right. Well, it will be really interesting to watch this unfold. It's obviously, if Morgan Stanley's right, and there are those kinds of numbers at stake in the next 5 to 6 years, certainly this is going to be a hot button issue in Washington as people, as there is a bill seeking to make it all illegal. I was curious to get your take, Ron, on something that I'm not even sure qualifies as online gambling, and that's something that our chat room has been asking too: is can we define what constitutes gambling for the purposes of this discussion? So start there, and then I'll ask my follow-up question. Can you tell us what constitutes gambling?
Right. Well, the traditional legal gambling definition has 3 elements. There has to be the consideration, that's the bet you place. There has to be the uncertain outcome, which usually has to be based on chance. Some states vary on that. So sometimes you can avoid having something categorized as gambling because it's a game of skill. So that's how some states allow poker online, because it's deemed to be a game of skill. Then, of course, there's reward. That's the payout you get. So it's consideration, chance, and reward.
So my follow-up question had to do with fantasy football, and maybe that, or fantasy sports in general, and maybe that counts as a game of skill because you're picking players and wagering based on their abilities, etc. Yeah,
well, mine, clearly I have no skill on my team if you look at my team.
Right.
That is the argument about fantasy sports. Some people play it not for money. Actually, my league is not for money. But the other argument, if you play for money, the argument is that it is, in fact, a game of skill. And there's some operations, that have the daily, or I should say weekly, I guess, fantasy games where you pick a new team each week. That's as close to gambling, I think, as you can do online. And that's got to be based upon the theory that it's a game of skill, not of chance. Some states, and I know Tennessee and Arkansas, I've recently spoke in both of those states, they don't care whether it's skill or it's chance. You can't bet on a game even of skill. But many states, the traditional rule is you can bet on a game of skill. That's why a bet placed on a golf course is in many states not illegal. Some states it is.
Gotcha. Well, Michael, I thought you'd get a kick out of this, that 3 law professors have gotten together. And this is taking me back to episode 276 of our show a few weeks ago when we had Colin Starger on. He is of the SCOTUS Mapping Project. This is a fantasy Supreme Court of the United States League where these law professors have gotten together, and they think they have a model, a data crunching model based on, goodness, you can definitely go to the article and dig deep into how they've come up with this model. I'm sure it's based on, who's authored what opinion, and sort of taking the Supreme Court in a very methodical way, and what the past decisions of the justices have been. I'm sure all that factors in. But they have this model that they think can fairly accurately predict the outcome of Supreme Court cases, and they want to test it, sort of a la IBM Big Blue against people, and see if man can beat a machine, as the article here that we've linked, that we have in our discussion points, puts it. So you can go to this Fantasy SCOTUS League and you can handicap the Supreme Court, give your predictions. And let's see, how do you win the $10,000? The human with the most accurate predictions wins $10,000. So they're putting their league to the test. What do you think, Michael?
Well, that's very interesting. I haven't studied in detail, but I can see how you could do it, right? You have a large body of it. So machine learning works best when you have a ton of training data. And so you have all of these decisions. My understanding is that these legal opinions are written in highly regimented, nearly artificial language. So mining them is going to be relatively easy, and you can attribute who wrote which opinions. So I'm actually only surprised that it has taken this long for this to come out. It's one of these things that's obvious in retrospect, and I'm really excited about it.
Well, it's pretty funny backstory here. One of the creators tried a similar kind of fantasy SCOTUS site back in 2009. Says he launched it as a joke and didn't think anyone would want to play, but 25,000 people signed up and the best player predicted 80% of the cases accurately. So there are people who definitely get into this. You can read more about it, as well as the rest of the topics we're discussing today. You can find the link at delicious.com/thisweekinlaw/279. What do you think, Kevin? You going to sign up and start trying to predict the outcome of Supreme Court cases?
I think that's a loser's bet there. I think there's plenty of factors that go into it that the computers can't predict. But that's kind of the fun too. I mean, maybe they can come up with some sort of a wild weasel type of algorithm, where they can figure out which cases are most likely going to could go a little differently. But I think it's all in good fun. Hopefully, personally, I always enjoy following up on SCOTUS activities through sites like SCOTUS blog and stuff like that. I'd be real curious to see what somebody like that who's really followed the SCOTUS opinions that closely, how somebody like that might fare against the computer.
Yeah, well, Thomson Reuters seems to think there's a business model in this. They have something called Lex Predict that is attempting to empower. Here's their marketing language: empowering the future of legal decision making by purporting to be able to predict for you how your case might come out. And they talk about taking this beyond the Supreme Court to cases in lower courts too. And as I think through this, I think that as soon as a judge who is a human being and has real ingrained biases against being predictable, I would think, as soon as a judge thinks that someone's trying to ballpark them, they're going to start going the other way. What do you think, Ron?
Well, I think this is a brilliant insight. Number one, I'm interested in the game. I can see getting some students involved in that and just have some fun with it. But, I have had investors contact me before when there's litigation involving a gaming entity or something, and they don't know how the outcome's going to be. And so they want an analysis of what I think is going to happen with the case. And if it goes one way, the company's a good investment. The other way, the company's a bad investment. If there is a market, if you can get a collective opinion from a lot of people who study something, that information is far more valuable than my opinion. I mean, you could get the sort of the predictive ability of a large group of people, and so I absolutely think there probably is an investment interest, business interest in something like this.
Yep. Well, you're not alone, apparently. Let's take a break now and put our first MCLE passphrase into this show. We put these phrases in case you are listening to the show in hope of receiving professional credit in either the legal or another field. And sometimes the oversight bodies who monitor that credit like to have something concrete you can show you actually watched or listened. So we embed a couple of phrases in the show. The first one for this show is going to be fantasy SCOTUS. So jot that down if you are listening to the show for professional credit. And if you want some more information about that, head on over to wiki.twit.tv, find our page there, the This Week in Law page, and there's lots more information there about at least receiving continuing legal education credit in the various United States jurisdictions. Let us move on down the Silk Road briefly. Kevin, you pointed toward a story earlier this week that points out an interesting civil or criminal procedure conundrum in the prosecution of Ross Ulbricht. Can you tell us a bit about it?
Sure. I'm certainly not a criminal lawyer myself, but I thought this was an interesting case and was worthy to share. Basically, Silk Road servers were seized, and there is some concerns by Ross as to the legality of that. The problem from his perspective is that he is trying to show that he's not affiliated with that, and the catch-22 situation is he can't object to the seizure of the servers unless he were affiliated or had some personal standing to object. And since he didn't have, the ability to object while at the same time, preserving his argument that he's not involved. Sort of the catch-22 situation that he's in there.
So there's information that he would like to block the prosecution's use of, but in order to come in and say, hey, you seized those servers improperly, he has to actually exert some degree of control over them or admit, hey, those were my servers that you seized improperly.
Those are my servers. Yeah, they've been illegally seized. That would go against the argument that he's trying to make in the case. So his sort of the catch-22 situation is, he can't, do one thing without, getting himself messed up in the other way. So.
Poor Ross. The case drags on. Ron, as a law professor, do you see any problem with this?
Yeah, no, I think this is fascinating. It's very similar to a discussion I had just this week in my criminal procedure class. So Denise, if you and I are speaking to one another on the phone and the police listen in without a warrant, and they get some information, they find out that, I'm a drug dealer or something, they try to use that against me, I have standing to object for the Fourth Amendment and have it excluded because they've violated my rights, they've violated your rights. If, on the other hand, we're talking about Kevin, we're saying Kevin is a drug dealer, and they want to use this information against Kevin, he has no standing to object to what they did to us. And that's kind of what we have here. You have to have standing to say that, I was my rights were violated in order to have the stuff excluded. So the defendant here, if it's not his computer, he doesn't have standing. The evidence is not suppressible.
Could you see a court having an issue with that, though? I mean, just as, it would seem like Kevin would have standing if there were some sort of intrusion that someone else could object to but did not. Shouldn't the third party, once removed, have some way of asserting an objection that doesn't tie their hands?
Yeah, I get your point, but there are cases, this has been around for this is kind of old law that you only get to invoke the exclusionary rule if your rights have been violated. And if these were not his computers, his rights were not violated.
So, Ron, this Michael, what about questions of scale? Again, I'm not a lawyer, but in your telephone example, right, there's a limited number of parties that are likely to be involved, but what if we're illegally seizing computers that have millions of names or something like that. Is any precedent in that area?
Well, I haven't seen that exact case, but the premise is that exclusion is a remedy for someone whose rights have been violated. And so if I seize your computer, your rights are violated. Anything I learn about you can be suppressed. If I learn information about somebody else, the theory goes that you could have voluntarily turned that over to the police. So since you could have voluntarily turned it over, you had it in your possession, those people's privacy was not violated by what happened in your computer. Does that make sense?
Yeah, I get it. I was just wondering if something on the scale of Gmail or something like that, right, where there's such a large volume of data that one could illegally seize and then just mine for whatever you're looking for, right? I was just wondering if scale made any difference in this, or I guess it hasn't been tested yet.
Well, I would say that, for instance, if we went to Google, Gmail, whatever, and took all that information, we are at some level we're invading everybody's privacy when we take that. That's different than if I just happen to take your computer and get information that's on your computer and it relates to Denise. Her rights were not violated. Your rights were, but so anything we try to use against you would be suppressed, but not what we try to use against her. I don't know if that answers your question, but
it's making me wonder at the fact that I actually did really well in criminal procedure in law school because I'm feeling kind of lost and at sea with all this right now. But I think I'm not alone in that sense. It probably bears mentioning that when people do, and this happens routinely all the time, that law enforcement and others are constantly serving court orders and subpoenas to entities like Google and phone companies where there's lots of data about lots of people, that aren't they, Ron, required to demonstrate they can't just go on a fishing expedition for, all emails of Southern Californians between March 31st and July 31st. There has to be some specificity to the request, correct?
Absolutely. There has to be not only specificity, but there has to be probable cause. A reasonable person would believe that we're going to find a particular thing at a particular location. So we're suspicious of someone involved in terrorism. We have to have a reason to say why that is, and a reason to say we expect to find evidence in these emails in this particular defined time frame or whatever.
All right. So if you are running something like Silk Road, beware of who has your servers and what sort of objections you want them to assert on your behalf, I suppose, is the lesson to take away from this. Tongue-in-cheek, of course. Don't be running something like Silk Road. Let's move on to a copyright issue that I think will be interesting, certainly has import to the world of technology. So folks, remember the Oracle versus Google case. We've talked about it a lot on the show over the years. There has been a recent development there. Hey, we were just talking about handicapping the Supreme Court. Someone might want to handicap what on earth the Supreme Court will do with Google's request that the court get involved in the case. Google has filed a petition for cert to the Supreme Court, claiming that this is a very important juncture, that the Supreme Court has to get involved and hold that Oracle does not actually have the copyright that it was deemed to have in the lower court case here. And that copyright is in snippets of code that make up the APIs that were at issue in this case. and has, according to Google in their petition, very wide-ranging effects. In Google's view, they write, a newfound copyright on Java APIs is akin to granting a company a monopoly over the QWERTY keyboard or the familiar automobile arrangement of steering wheel, accelerator, and brake pedal. And I'll pull up the petition and tell you exactly what Google is asking the Supreme Court to look at. If I can scroll to that part real quick. Here we go. The question is whether copyright protection extends to all elements of an original work of computer software, including a system or method of operation that an author could have written in more than one way. So, Michael, I'm thinking that whether or not the Supreme Court decides to take this on would be important to folks in the computer science arena.
So I can't predict what the Supreme Court will do in this case. Right. I can't imagine asking any technologist not affiliated with Oracle that would think this is a good idea. I mean, the essence of APIs is, it really is sort of like alphabetizing the names in the phone book and some of the other things that we know are not copyrightable. There is an element of art and design to APIs, but their essence is about public exposure and being used in new and different ways. And so my limited knowledge, not again from a legal grounding, but wow, what a terrible decision. Mm-hmm. And so I hope Google is successful in getting this case heard and hopefully appealed. The implications for technology development are going to be huge. If you can lock up APIs like this, then you're going to really stunt development and innovation.
Right. So, Ron, do you want to take a shot? First guess in your Supreme Court fantasy prediction league, how this petition for cert might go?
Well, I hope that the court will listen to experts like Michael, because this was something I wasn't very familiar with until looking at it just this week. But it seems clear to me that this is if this is upheld, the lower court, it's going to fundamentally change the way everyone uses the internet. So I hope that the court will accept the petition and reverse what the holding is below. In terms of knowledge, I don't know whether our justices, the issue will be whether our justices understand the technology behind this. And I think with their clerks and such they will, but if they do, I think from a practical matter, we need to have the decision overturned.
All right. Kevin, any thoughts?
Well, my review of the article showed that there were only certain claims that were made. It wasn't the whole API that was protected. I believe there were certain calls that were made to sort of get into the Java interface there. I'm afraid I'm certainly not a computer science expert myself, so I'm probably messing up in my explanation here. But there were certain calls that were made such that it evoked the interface, and I think that the copyright was limited to those particular elements of the API, and it didn't cover the whole range of options that were available once you were in there, and I think that sort of is sort of a limited scope to it. So whether or not this is doom and gloom for the entire software industry, it's hard to say. I think that if the Supreme Court decides to hear it, we should know in the next few weeks or months whether or not they actually will grant cert. All we know at this point is that the petition has been made, and we'll have to see whether or not the Supreme Court will actually agree to take the case. Otherwise, it will still be back for proceedings, which include at this point Google, determination as to whether or not Google might have a fair use type argument to make here, that there may be a fair use of these particular code snippets as part of the APIs. So, but before that issue was determined, Google requested this immediate petition. So procedurally that's where this is at. I don't think it's as doom and gloom as it might otherwise be, but at the same time it's certainly no laughing matter that that the fact that copyright could go over to certain parts of an API could be problematic for the future.
Yeah. In my Supreme Court prediction league, I think I would ballpark this as a no, that the Supreme Court probably won't take it up now because Google is teeing it up at an interesting and unconventional procedural time. Its remedies in the lower courts are not yet exhausted. He's supposed to go back. They're supposed to go back and have, as you said, Kevin, more proceedings about the defenses to the infringement claims that were asserted against them. So the Supreme Court usually, it takes a very small amount of cases to begin with, and certainly likes them to be completely resolved in the lower courts before deciding to engage. Google's point here is that this is such a critical issue that we need your help now, court, and maybe they decided to do this knowing that it was a long shot because, hey, sometimes long shots pan out. And even if it doesn't, at some point there may be an opportunity to put this case before the Supreme Court in a more procedurally conventional way. And by doing this now, Google is sort of seasoning the court to what the issues are here, and maybe that'll be good in the long run. So thought it was an interesting development. Speaking of Google, let's look at something that is still in the copyright arena, but because it involves YouTubers, also involves things that entertain us. So I put it under entertainment. A couple of points related to Google, YouTube, the DMCA, and Content ID this week. Number one, just a factoid, interesting thing to bear in mind when juxtaposed against the second story that we're going to get to in a second, is that YouTube has released numbers that demonstrate that it has paid $1 billion since 2007 to rights holders using its Content ID system. So Content ID was Google's and YouTube's response to the various infringement claims brought against it over the years, including the Viacom versus YouTube suit. And apparently it is becoming profitable for those using Content ID. The problem, as pointed out by Megan Geiss, if I'm saying her name right, at Ars Technica, is that Content ID, that while it's a good compromise for Google and the rights holders, is far from a perfect system in as far as the creator and uploader goes, and tends to act in a way that can be overbroad and imperfect and take down things that or come up with matches for things that actually are just fine and legal. Our second story has to do with DMCA takedowns on Google, not from Content ID, but from a company employed by Microsoft. Chris Pirillo and others found themselves on the wrong end of some DMCA takedown notices just this last week. And they did not involve any sort of content in their videos that were found to match Content ID and then be a problem. But because some product keys for the use of Microsoft products apparently were posted to the comment section of the videos. And so Microsoft has employed a company that is helping it suss out misuses of its intellectual property. And one of the things it did was identify the product keys in these videos and send DMCA takedowns for the videos. So that's a bit of a reach for the DMCA here. And Microsoft has apologized and says it's working to reinstate the videos. But Kevin, what do you think about the chances of a legitimate DMCA claim being levied against something because an opportunity for infringement took place in the comments to a video?
Yeah, that is a bit of a stretch. I think the purposes of the DMCA is to get content down that has been directly infringed. Here you have a video and somebody else has the same content up. That they've got their rip of it and they're putting that up under their own advertising, their own branding. They're the ones making money off it, not you. That's one of the ways that the DMCA is designed to protect. Merely having it in the comments, as Microsoft acknowledged, that's a bit of a stretch, and they apologized for that action taken by their vendor. Something I urge people to keep in mind is that just because you hire a vendor for it doesn't get Microsoft off the hook. Microsoft could be liable for sanctions for improper use of the DMCA procedure in these types of cases. If they show a pattern and practice of this, it is each takedown is supposed to be judged on its own merits, and supposed to conduct a good faith review of whether or not something qualifies for takedown under the procedure. And in this case, it's hard to say that some live person at Microsoft actually went and actually reviewed what was happening, because if they would have done that before the would have been done, likely, they wouldn't have had to apologize. But at the same time, you have to acknowledge, the fact that there's, hundreds of thousands of these types of things going on. And that is why Microsoft engaged this vendor in the first place, is
Right.
sort of this impossible situation that the DMCA puts certain people in, who are content providers, is, the fact if they've got popular things that, now they're 24/7 copyright police, as opposed to being the creative people that they would otherwise prefer to be.
Right. The company that was working with Microsoft, this is from Wired's reporting on this, Clint Finley there. It was called Marketly, and was founded by former Microsoft engineer Pulin Thakar. And it uses algorithms to spot piracy and counterfeiting on the net. And according to Google's transparency report, Marketly has requested that Google remove nearly 11 million different URLs from its search engine on behalf of Microsoft alone. So none of this is giving me a whole lot of faith or optimism about how Microsoft is going to treat its new property, Minecraft, and the various copyright infringements that are involved in that. If their solution is just, here, we're going to turn it over to Marketly and let them send out takedown requests. Popular MMOs and other YouTubers that cover Microsoft are going to find themselves in the same situation as Chris Pirillo is. Ron, any thoughts about either the efficacy of Content ID or overreaching with DMCA notices?
Well, it just seems like it's very difficult to keep track of these things. And we find so much internet stuff like that. What it reminds me of is a gambling issue when we try to prohibit gambling sites, and you've got to keep track of what is a gambling site, and people change the names, and just the idea of any entity that's trying to monitor all the internet, looking for copyright infringement, looking for various kinds of illegal activity. It's really tough, and so you rely on computers, and that always removes the human element, and that's where mistakes happen. And I think we need to understand mistakes will happen and just correct them as quickly as possible.
All right, Michael, any thoughts before we move on?
Yes. So this is this was clearly a mistake on Microsoft's part or their contractor. But on the other hand, to be fair, if you were in the business of distributing product keys or other illegal information, setting up a site or going to YouTube or something like that, and then having an agreed upon URL in which people post content spam. In this case, the content spam is the actual intended target, right? So you can imagine a scenario in which you used a popular service to distribute this material, and then you had some kind of defensible position. Well, I'm sorry, I didn't remove that comment. That was, I don't know how that got there. That was just a video of my cat or something like that.
Right.
So in this case, I'm sure it was a mistake, but you could easily imagine a scenario in which people actually do distribute information in this way.
Yeah, I mean, I definitely just anecdotally am familiar with people with inactive blogs, for example,
Sure.
with still active comment systems, and you go and you see that there's a whole burgeoning life going on in the comments because it's sort of an anonymous, under the radar way
Right, it's
for
like weeds. The weeds have taken over the yard or something like that, right?
Exactly.
Yeah, so I actually have some experience. So for recreation, I blog about music, and I link to YouTube videos in the blog. And so I've received one of these automated takedown requests where the blog post was automatically removed because, and of course I was pointing to things that existed on YouTube, no content that I uploaded or any, and it still managed to get a takedown request. And so I've been on the receiving end of that, and that was disappointing as well. But the interesting thing, we actually did a study a couple of years ago based on my experience with blogging and wanting to link to videos, and that actual half-life of a music video on YouTube is often quite short. Right? It's in the matter of weeks or months. But at any given time, you will find literally hundreds, sometimes thousands of copies of the same song on YouTube. So the individual URL often will die very quickly. And so you'll come back to the blog a month later and the link's broken. But if you knew what the content was, you reissue a search and you will find multiple versions. Now, each one of those might die as a result of a takedown request or something. But, the content actually never disappears. It just moves from place to place.
Right. Hey, let's get into talking a bit more about Michael's project Memento, which, because it archives the web, also has some privacy overtones. So, Michael, we talked a bit at the top of the show about Memento. From what I understand, it's a way to surface not just the Wayback Machine, but other ways in which the web is archived and make that more easily accessible to folks. Can you tell us what sort of pushback you have gotten, if any, from the EU, or how you all are thinking about what Google is going through with the right to be forgotten?
So that's something that hasn't hit us yet, but I think it will. So it's disturbing on a number of levels, right? Because on one hand, the EU ruling says you can't remove the information, you just remove it from the search engine. And so you inhibit discovery, not the essence of truth, right? So if it's a newspaper article about something. So the original site might hold on to it. We try to archive it in the web, right? Or in multiple archives, because any individual archive might die as well. But when you inhibit the discoverability, that's a whole different issue, right? Of sort of editing the historical record and what actually happened. So far, web archiving is not popular enough or well known enough to have really, as far as I know, hasn't been addressed in these legal decisions. That's just a matter of time. And I'm not sure what we're going to do on it. It's interesting because Old Dominion is a member of the IIPC, that's the International Internet Preservation Coalition or Consortium, I forget. And it has has the Internet Archive, the Library of Congress, a handful of people, but it has many European members. And the Europeans, and if I can speak in generalities, the national libraries, the national archives, they do a tremendous job of archiving their top-level domains, the UK websites, the .fr websites, etc. And they have a very much an interest in preserving their cultural heritage as it's represented in these websites. Some of those archives are currently public. A lot of them are currently dark. And so they're archiving the material, but you can't access it. So for those archives, these rulings, it's not clear how discoverable it would have to be in a dark archive. So for example, for the French National Web Archive, you have to go to a special room at the BNF in Paris to access the material. So if Google gets a takedown notice, does it propagate to the reading room in the BNF? That hasn't been explored. That's something that we're really concerned about.
Mm-hmm. Well, you were talking about the top level domains getting good treatment in the EU. Kevin and I were talking before the show, and maybe now is a nice time to bring it up, about just the proliferation of, and maybe Kevin, you can explain what constitutes a top level domain these days. You know, .com, .net, and .org seem to have a lot of company. And it seems to me like .vegas and .nyc might understandably get different treatment than things like .com, .net, and .org. Any thoughts on this?
Well, there's, these new top-level domains, as you mentioned. Very briefly, a top-level domain is anything to the right of the dot. So .com, .net, .org are the most famous ones because they've been around for so long. ICANN and its infinite wisdom decided that there should be thousands more. And so they started a process allowing for people to come up with new, in their mind, what they call generic top-level domains. And the idea being that it should be something that would allow for website on a particular topic or geographic area. In this case, .nyc is designed to indicate people living in New York City or relating to New York City. But it's not, exclusively for that. The whole purpose of doing this is to open it up for, people to express an interest. And there's a whole procedure that ICANN's gone through, and the ones that have gone live are the ones that have actually made their way through this whole process. It's a very expensive process for someone to operate these new domains. It's an incredibly expensive proposition. There are certain brands that have decided to do this as well, and so they've got domains coming online eventually for their own private use. But for the most part, these are things like .nyc and so forth are a private company that's come in, and there's a lot more of we would call a land rush type situation where people are coming in trying to register these domains. There's procedures in place for trademark owners to register their trademarks with the Trademark Clearinghouse, and at least you get notified before somebody registers these a domain that matches your character string. Doesn't necessarily prevent it, but at least you're notified, and then you can go about and there's a quick and dirty resolution process, the Uniform Resolution System (URS), and it's for these new top level domains. But it's the article that you linked to in our show notes. It involves land rush in the .nyc and pointing out that there's a lot of squatters that are on names trying to remember exactly which ones are which. Let me see if I can figure out here in my notes. I think New York Jets, that NYC is owned by somebody named John Kalman, who lives in New Rochelle, and it has nothing to do with the Jets organization, as far as the person who wrote the article knows. Oh, in fact, it points out that the domain is for sale, so it's
Right.
certainly not that. There's
but you could certainly envision the guy who is the hugest Jets fan ever and decided, oh, I'm going to run my fan site for the Jets on a .nyc domain, and I'm going to call it NY Jets. And, I mean, obviously there are trademark issues there, but he's got, at least a colorable claim to having the site under those circumstances, right?
Well, except for that person put up a for sale sign, so there's your presumption there.
Right. No, I was spinning a hypothetical.
That's yeah, but if okay, let's you take that out. So in this case, that certainly could be that could be a legitimate use that that comes out, and that's certainly a possibility. They could do that. That could be a legitimate fair use, under the regular dispute resolution procedures. That could be taken in consideration. Whether that's going to be taken in consideration in all these other dispute resolution systems. I believe that there still are. The URS still looks at whether or not something's been registered in bad faith. But it is supposed to be a quick and dirty type system, and certainly possible that that could go wrong too. So,
Michael, with all of these thousands of top level domains out there, it seems like your job would be complicated over and over again.
Well, yes and no. So.
Okay.
As far as discovering sites, we basically archives function as crawlers. You just load a page, see what it links to, load those pages, see what they link to, repeat until you grab everything. So in that sense, you just crawl. And as long as people are actually linking to these sites, then they'll be discovered and archived. Now, aside from that, the proliferation of top-level domains is a remarkably bad idea. And I'm very sorry that it has been put in place because it leads to these land rush scenarios. And I'm going to blame Kevin because I heard earlier that his company was involved in handling squatting issues, and so I think it was Kevin, and we'll say it's Kevin's fault for the proliferation of top-level domains, because there's really no overarching need for them. If you're the world's #1 Jets fan, then you can create your site under a different name. And since search engines are the primary source of discovery, if your site's popular, it will be discovered. So, I mean, I think the main reason for proliferation of domains is it's you make money by selling them, and two, you make money by confusing customers, and the whole operation seems to be in bad faith from my opinion.
All right, Kevin, what do you do for clients with all of these thousands of new domains coming online? You mentioned there's some sort of notification if you have a registered trademark, but I mean, are people going to...
Well, that's if they register with the Trademark Clearinghouse. One of the things that my new firm does is we're affiliated with a registry that has... operates its own registry that operates as a registration agent itself through them to the clearinghouse. So that's certainly a thing that we provide for our clients. But in terms of that, watch services are certainly enabling. There's an option depending on the client. Just because you're registered with the clearinghouse, doesn't mean that you're off the hook for your obligation to your client to look for things that may develop So that's certainly one thing we also do for our clients is to provide these watch services to look for these types of things, and in essence, help them prioritize what's going on out there.
Well, right, because
just because somebody's
maybe
I
if
was
you're
just gonna say-
Coca-Cola, you get Coke.nyc and everything else there is out there, or Coca-Cola. But if you're not, then it probably just is cost prohibitive to try and lock them all up.
It is extremely cost prohibitive, and that is why, depending on the client, obviously, we'll take sort of a wait and see type approach to see, what happens with certain domains. So certain things we'd pounce on right away, just because there's, just looking at the URL, there's no way possibly it can be used for anything other than infringement. But other things, might develop into something, as you said earlier, which is, a fan site or something, in which case then, depending on the client, that might be an option. But at the same time, we also have clients that they're very sensitive depending on the particular domain. The article that you linked to, gives Disney as an example. That they felt that they were extorted when the XXX domain came online, and that they felt the need to go out and spend money on domains that they had no interest whatsoever in using for their own business purposes, but merely they went out and they reserved them so others couldn't use them in the XXX domain system under the Disney brand, and.
Right.
That's obviously a concern, but I think ICANN implemented the system over the objections of the trademark lobby. I don't think those of us in the practice were that thrilled that these domains came online. But it's a fact that ICANN has done it, and we as counsel, it's our job to help our clients figure out a reasonable approach to handle these types of things as they occur, and how to do that and live within budgets. It'd be wonderful to go against everybody in the world that's infringing, but that's going to cost more money than many legal departments want to spend.
Yeah, I think you just gave us our second MCLE passphrase for the show, and that's going to be Snow White XXX. Poor Disney. I'm sure they had many of those they had to squelch when .xxx came online. Let's circle back to the privacy ramifications of archiving the web. We sort of went down a little side tour there based on domain names and archiving the various and sundry proliferating world of them out there. But so what are you going to do, Michael, when someone from the EU comes to you and says, okay, we need a way to make sure that this website from 1998 is no longer viewable?
So this is, I guess, going to be dependent on who's running the archive. So places like the Internet Archive, Brewster Kahl's been pretty proactive about taking down sites that people don't want in the archive. There's a form you can go and fill out, but that works when there's one well-known archive, right? So when we go to dozens or, at some point in the near future, hundreds of public web archives, because they are springing up as that people are trying to figure out how to commercialize them. And that's going to be a lot more difficult as far as handling these takedown issues. Now, it might not show up strictly in the EU context because right now, the pages of the web archives are not indexed by Google and other search engines, right? So in that sense, the archived web pages are not discoverable from search engines, and so will not get caught up in the initial EU ruling. But this is something that that we've internally struggled with. So, for example, one of our studies that generated a lot of attention a couple of years ago, one of my grad students is from Egypt, and he was here, and as the Egyptian revolution was happening, he's of course tracking it remotely. And then we went, after 1 year after the revolution was over, we acquired a whole bunch of tweets of and about the Egyptian revolution, and we looked at how many of the tweets disappeared and the resources that the tweets linked to and that disappeared, and we were really surprised. So about 11% of the resources that people were linking to or in tweets disappeared, and then we found maybe similar percent, 10, 11% of the tweets themselves had disappeared. So in many ways, this was the first revolution that was taking place in social media, and social media playing a really huge role in this. And so people were crafting history based on this material. And of course now, and at the time we're thinking, well, this is great. We're trying to preserve this material for posterity. But now you have to think about fast forward 5-10 years, who's running the country at this point, and will people want to be associated with the things they said in 2011, and because there could be repercussions further on, right? So oftentimes as technologists, we sort of view ourselves as we're the good guys, performing the watchdog operation on bad governments, right? And because there's just too many examples of governments trying to edit their own records and so forth, and web archiving is a great tool for capturing that. But then you have to think about what if the bad governments are in fact using web archives as for a cultural purge or something like that. And to be honest, we don't have a good answer for this.
All right. Well, we wish you luck as you face those daunting challenges. Another daunting challenge is being a parent of a teenager using social media. And our final story has to deal with the law of the social web, and it's also going to be our tip of the week. Okay, the tip part of this story, it's going to be real simple. I can't distill a more sort of practical, this is how you handle your child's use of social media tip, because it's kind of a complicated morass here that I'll get into in a second. But my tip is going to be, if you have a minor, if you're a parent with a minor child legally using social media, so they're probably over the age of 13, show them this article. Show them that this happened. And what happened here is there was a middle schooler in Cobb County, Georgia, and actually two middle schoolers who decided that they did not like a classmate. Or for whatever reason, whatever motivation, we're going to set up a fake Facebook page for one of their classmates and populate it with a bunch of stuff that was both unflattering to her physically and suggesting that she was a racist, was a lesbian, various other things that were defamatory in nature. So the parents of the victim child, who was a girl, ultimately decided to sue over this. I think they probably went through many steps before then, but they brought a civil defamation lawsuit against the parents of the two students who set up the Facebook page, a boy and a girl. One of the groups of parents that were sued just didn't respond. There's a default against them in the case. I'm not sure what will happen with that. The other parents did respond and asked the judge to enter summary judgment in their favor, saying, hey, we can't be sued, for the acts of our child, I guess, would be the assertion in the summary judgment papers, though I have not read them. On appeal, a 3-judge panel decided, nope, that's not true. We're going to go ahead and let this go to trial against you, parents. And one of the things the appellate court noted was that the site remained up for quite a long time, and that the parents did not monitor it at all, take any steps to bring it down. And so let's read you from the appeals judges themselves. During the 11 months the unauthorized profile and page could be viewed, the Athorns made no attempt to view the unauthorized page. They took no action to determine the content of the false, profane, and ethnically offensive information that Dustin was charged with electronically distributing. They did not attempt to learn whom Dustin had distributed the false and offensive information to whom he had distributed that information and whether the distribution was ongoing. They did not tell Dustin to delete the page. Furthermore, they made no attempt to determine whether the false and offensive information Dustin was charged with distributing could be corrected, deleted, or retracted. So here the parents are saying, or the court is saying, look, the parents, you should have taken some of these steps, and in the absence of taking those steps can be potentially liable for defamation for what happened here with your child. Now, I don't know too many parents who could keep tabs on every single Facebook page, or social media page that their children might be involved in, but that seems to be the expectation from the court here. And also worth noting, and noted in the Ars Technica coverage of this, is that not only civil liability might be the result, that there are many, many states that have anti-harassment and anti-cyberbullying laws on the books where criminal liability might well be triggered by this kind of conduct too. So I'll kick this to our Crim Pro professor on the show today. Ron, what do you think of this particular case?
Well, it's a fascinating case. You're right in talking about it's an extension of the bullying stuff we've heard so much about. Mm-hmm. And normally, though, people are responsible for their own torts, even children and parents. So normally you don't see parents held responsible for things like this their kids did. The difference, I believe, in this case is that the court held that the parents knew for 11 months that this Facebook page was up there, and they did nothing to take it down. In some ways, suggesting, because probably the parents are paying for the internet access, the ability to be on Facebook, all those kind of things. So in some ways, I think you can say arguably they joined into it in this case. Now, you can avoid all liability by being a reasonable person and find out if your kids do something like this. You punish your kids and you make them stop it and you take it down. That's what people should do. I think that's appropriate that people do that. Whether the parents should be civilly or certainly criminally punished, I've got some concern about whether the law should extend that far. But I certainly agree that this was a bad thing. And if you know about your kids doing something like this, you should put an end to it.
Yeah, and that's why I made this our tip of the week, just to share this article with your teen kids if you have the chance, because just having observed the species in the wild, this kind of thing, even though these kids clearly crossed a cruelty line that I would hope most kids would not, without crossing that line, I could certainly see kids because they don't care about terms of service, thinking it would be funny and a joke, and maybe they could make their friend laugh by coming up with a fake
Denise,
Facebook page for them. Yes?
Denise, so what I didn't see in that article, and I don't know if that shows up elsewhere, is perhaps the parents of the offended child. Facebook has a well-documented takedown procedure, and at some point, it would seem that you would contact Facebook to try and get this page removed, right? It's a clear violation of their terms of service. And so I wonder, obviously the other parents should have done something, but the original set of parents, maybe they didn't pursue the best course of action either.
Yeah, I'm not sure. The original reporting on this came from the Atlanta Journal-Constitution. And I don't think it goes into that particular aspect of what other steps the parents took. But even if they were successful in getting the Facebook page taken down, that wouldn't eliminate their ability to also go after someone for defamation. So
Sure,
even
but
if they,
it seemed
yeah,
it said that one of the original points is, hey, you did nothing for 11 months, and I'm thinking, well, what did you do in this 11-month time frame? All right, Facebook's very clear that you can only have accounts in your actual name, and you can't have these fake accounts, right? And and Facebook's gotten all kinds of pushback for the takedown of accounts for transvestites and so forth, where they don't use their real name and so forth. So what did the original parents do? And I know I guess we don't have all the information on this, but it does make one wonder what happened. Did anybody do anything in this 11 months?
Right.
And my guess is that Facebook gets hundreds, if not thousands, of these kinds of requests every week, and that I just don't know the alacrity with which they can respond to them all. What were you going to say, Kevin?
I was just going to say linked to from that article, it was the 28-page opinion from the from the court, granting the reversal. And I do believe there were some facts in there, but I don't remember all the exact details. I believe that the parents did try to take some steps, but exactly what steps they took and whether they took, steps that, would have been effective, if they tried it is an open question, because I simply don't recall, those particular facts. The ones that I was focusing on more were the legal theories in which the court was holding the parents liable for, and it's pretty clear that they're holding them liable on a negligence standard. In that, they were aware of it, they punished their child, they were aware that the school had punished their child, they did their own punishment at home for a week, but at the same time, they didn't take any steps to take it down. There was an alternative theory of liability in which the parents of the child that the site was about tried to hold them accountable under sort of a chattel's approach, saying, you're the one that was responsible for it, and it's essentially said that they couldn't hold the parents liable under that theory because it was not an account that the parents had the password for. It was not an account that the parents themselves had set up or directly controlled. In essence, that they could have, under this theory, that they could have had their child take it down, but that wasn't enough to saying that they controlled, that particular account sufficiently for them to be directly liable for having it. Instead, the sole theory that's going to go back to the lower court on is whether or not the parents were negligent in their handling of this situation.
Yeah, I'm back to being with Ron in that a whole lot of communication and guidance for kids using social media is a good idea, and letting them if you can also hold over their head, it's not just you who are going to get in trouble for this, potentially mom and dad are too, that maybe it will take on some more force and importance, and also just that we're all human. I think a lot of the stories we talk about on This Week in Law have to do with the fact that people do what technology lets them do without necessarily thinking too much about the consequences of it. And the consequences definitely come into play. It's, I think, why we have a show. So going over those consequences with kids who are, again, having observed the species in the wild a lot, they're all about, what we can do, and isn't it cool that we can do it? Let us move on to our resource of the week, which is Memento, Michael Nelson's project and project of Old Dominion and the Los Alamos Lab. So you told us a bit about the project at the beginning of the show, Michael. Anything you want to add to that, or any way in which people can contribute or help the project?
So the page that you have up right now is a good page. This shows an extension that you can download and install in your Chrome browser, and it makes it easy to bridge between the past web and the current web. So basically, as you're viewing the current web, you can right-click on any link or in a page and say, I would like to query all of the archives for this page as it existed at a particular time. And that's what that image shows right there. It says get near and some dates. And at that point, this extension will query, again, a dozen or more archives and try to find the page closest to the date that you specified. Now, it doesn't guarantee that you'll find it. If nobody archived that page on that date, or maybe they didn't archive that page at all, then you won't get anything. But if it exists, and it can exist in some place that you've probably never heard of, Memento will go out and find it. So this is one of 2 clients we have that will do this, and this is probably the easiest thing that you can do to get involved and really, one of the things we're trying to do is raise awareness about the past web, because many people, again, are largely unaware of web archiving, and our web experience is sort of stuck in the perpetual now. You click on things and you always get the current version, which is often what you want, but not always what you want. So we want people to be aware that the past web does exist, and these clients help. They hide a lot of the details so that you don't have to worry about it, and these clients help you navigate back and forth between the 2 webs.
So as a complimentary resource of the week, I'm going to throw, every now and then we'll throw a book recommendation out there for you. I'm in the middle of reading The Circle by Dave Eggers, which is a nice complement to talking about Memento. I have not gotten far enough into the book to know, where it's all going to go, but it is about a company that seems to be in a agglomeration of Google, Apple, and Facebook, maybe. Certainly a fictional Silicon Valley company that has its hands in everything, and very gregarious and engaging founders, and a very committed group of people who live there, and the world's most beautiful campus. And they're all on a mission to make the world a better place. But again, I'm not far enough into the book to know exactly where it's going to go, but it has that. It reminds me of reading The Firm back in the day. You're going to work at this wondrous place, but there's something very dark going on under the surface. And what is so dark in the story has something to do with the fact that the company knows everything about everyone, and continually does initiatives. I think at one point early on in the story, there's the introduction of some surveillance technology that the company's going to put out there for people to use. And the motto that goes along with it is everything that can be known should be known and will be known. And so, I mean, it's somewhat in keeping with the sentiments of archiving the web and making sure that we have access to the historical web. And I'm not suggesting, Michael, that there's anything nefarious about what you guys are doing, but it's a nice kind of a thought experiment. I think this book is for the things that we talk about on the show. And what else did I want to say about The Circle? Oh, there's just some great humor to it too. People, getting snowed under by their social media, and it's definitely a good read. People who like the show will like the book for sure. So check it out if you have not already. Oh, there was a great discussion in the part I referred to where they're introducing new surveillance technology about how so much of human knowledge was lost in the dark ages, and how we owe our knowledge of the history of the times to a handful of monks who wrote everything down. And, that's part of the justification for their having surveillance cameras everywhere on the planet, including, not to give away too much of the book, but in, clandestinely installed in family members' homes without their permission. So it's a good book to read, and entertainingly written. So check it out. Guys, it's been really fun to chat with you here today. Really great meeting you, Michael Nelson. Thanks for the good work you're doing and all your thoughts and insights for us here today.
Thank you, Denise.
And Ronald Rychlak. I wasn't going to butcher your last name at the end of the show. I hope I didn't just then. Great meeting you. Great chatting with you. You're also, in addition to being involved in teaching Crim Pro and other subjects at Ole Miss and paying close attention to online gambling issues, aren't you also involved in the athletics program there?
I am. I'm the faculty athletics representative, chair of the athletics committee, and we got a big game against Tennessee tomorrow. So big excitement on campus, and I've really enjoyed and learned a lot today. So thank you for having me on.
We learned a lot from you. Really great that you could join us. We really appreciate the time. And Kevin, great to see you again. So good to see that you're doing well at your new position and to chat with you again on the show.
Well, thanks again for having me. I really appreciate it when I do get a chance to be on, and look forward to chatting with you again in the future.
All right, we will do that soon. In the meantime, we have been recording this show on a Friday. That's when we always record the show at 11 o'clock Pacific time, 1800 UTC. That's when you can join us if you like to watch the show live. Pardon me, sorry. And if you would rather watch the show on your own time, it is available on demand on YouTube, at our own site at twit.tv/twill, and on Roku and iTunes and however else you like to tune into this kind of programming. You should get in touch with me between the shows, too. I'm Denise at twit.tv, and I'm D. Howell on Twitter. We have a Facebook page and a Google Plus page for the show. Great ways to let us know what's on your mind, what you thought about the topics we discussed, what you'd like to see us discuss, and who you think we should invite on the show. We love all of your suggestions and feedback and encourage you to get in touch with us in any or all of those ways. And until next week, we will see you. Take care. This has been This Week in Law.